Welcome, everyone. Once again, glad to have you join us for a Venable presentation titled Newest Trends in Health Data Breaches, FTC, OCR, and AG Enforcement. We're going to get started now. As you may or may not know, this is part of a series that we're doing with a number of our health, privacy, data, payment, and related professionals in the healthcare space. I'm going to begin here with some general introductions, and then we're going to dive into the details here. I should note, if people have questions during this session, you should feel free to include them in the questions and answers chat box there, and then we'll do our best to answer during the course of the presentation, or if we don't get to them, we'll definitely do the follow-up. So we're excited to be here and looking forward to the presentation today. I'll start with me. I'm a corporate partner doing transactional work. I sit in our San Francisco office. I'm involved with general corporate transactions, commercial contracts, and also get involved with data, which is why I'm excited to be here and a part of this session. I'll next have Reed introduce himself and give a little background regarding his participation here.
Thanks, Jim. My name is Reed Freeman. I'm a partner in our Washington, D.C. office, and I'm a member of the e-commerce privacy and cybersecurity practice group, and am an alumnus of the Federal Trade Commission, and have been practicing in the area of privacy and data security since 1998.
Terrific. Thanks, Reed. Tora, you want to give us a little background?
Great. I'm thrilled to be here today. I chair our healthcare group here at Venable. I spend most of my practice focused on medical data and its uses and disclosures, and that's medical data subject to HIPAA or Part 2 and state privacy laws, and help put in compliance programs on the front end and help with breach response on the back end when things don't go according to plan.
Excellent. Excellent. Thanks, Tora. And Eric, you want to give us a little background?
Yeah, sure. Thanks, Jim. Nice to be here and great to see all of you. I'm a member of the firm's e-commerce privacy and cybersecurity practice group like Reed, and in that group, I help clients navigate investigations conducted by state attorneys general, Congress, the FTC, and other agencies as well. I also help clients address the compliance and policy issues related to privacy, consumer protection, and security. And by way of background, earlier in my career, I served 2 stints in the Illinois Attorney General's office and also on the Senate Commerce Committee and the House Oversight Committee in Congress.
Excellent. Thank you, Eric. One thing I'll note, I'm very proud of with my colleagues, and I've got the luxury of as being a Venable partner, is we've got a lot of folks who have got government and agency experience and background, which is incredibly valuable to just have a clear understanding of the pragmatic answers for a lot of the questions. I run into it myself. So hopefully as we get into this, we can hear a little more detail as to what we've got in the particular areas. You'll note, and this is a ripe area for the agencies and various law enforcement, in the fact that we've got federal FTC involvement, we've got OCR involvement. We also have state AGs, and our panelists here are going to be able to cover all three, at least giving us an overview of what we've got in those areas. So initially, I think let's start off with you, Tor, if we could give us a little background at the, I guess I'll describe it as the top level, but in the OCR space, particularly with HIPAA high tech.
That's great. Thank you. And the one thing I would note is we're all here today to talk about breaches in health data. And we've definitely seen an uptick of that. And I think it's due to a confluence of events. One, there's a huge regulatory push to electronic medical records and to patient access to their medical records. So we had high tech, which was the health information technology for economic and clinical health in 2009, which really got the ball rolling with billions invested by the federal government in health IT, largely in the form of CMS incentive payments to providers to transition from paper records to electronic health records. with a goal, the everlasting and persistent goal of making healthcare better, safer, more efficient, saving money. And that needed a little more attention, and we saw the 21st Century Cures Act that was passed in December of the last year of President Obama's administration. It was meant to further improve the flow and exchange of electronic health information, which is actually broader than PHI, which is the subject of HIPAA, but all electronic health information. And really, this year, we have seen new regulations go into effect that advance the interoperability of medical records, so EHRs talking to each other, and a new law on prohibiting information blocking, meaning that health information must be released by providers in certain circumstances, which is fascinating. Not the topic of today's conversation, but HIPAA is very much a permissive regime. You are allowed to release information. You only have to in two circumstances, which are to the individual and to the government. The prohibition on information blocking turns that on the head and says you must release information unless there's a regulatory reason or certain other exceptions for not releasing information. And then we have patients having greater access to their medical records, and the concerted effort to say patients really own their medical records. They need their medical records to make better decisions about their care. And then we have the quantified self with Fitbits and Apple Watches, and then every other type of app that is out there. So there's just much more health information in electronic format. And then we've also had the COVID-19 pandemic that we were slowly emerging from, which has led us to an uptick in breaches. And just drawing as an example, in 2020, healthcare data breaches of 500 or more records were reported at a rate of more than 1.76 per day. And the 500 is a key factor here because in my world of OCR, the 500 mark is when you need to report the breach faster to OCR. If it's under 500, then you have a little bit more time to report. And we had 642 large breaches reported by HIPAA covered entities, so covered entities and their vendors, business associates. And that represents about a 25% increase from 2019. And it's hacking and IT incidences that accounted for more than 50% of those breaches, 67%. So it's a large uptick. And we've also seen it in ransomware and phishing events. It's been very much in the news, and people have been sophisticated during this time of the pandemic. We've seen phishing emails from government regulators. There was also an OCR scam. People pretended to be OCR asking over the phone for PHI of entities subject to HIPAA. And then we've just seen scams to gain access to all the stimulus money and checks. So it's been an active time in 2020.
We also, I think, Tora, of late, we've even seen in the news our pipeline that's affected many in the East. So it seems quite broad and growing.
Exactly.
Yeah, and Jim and Tor, if I could just jump in quickly, I'll just say that it's not just the healthcare industry that's being targeted here. We're seeing an increase in ransomware and phishing scams across the board, and as we'll discuss throughout, a ransomware event or a sort of attempt for phishing, maybe the point of it is not identity theft, but it can also lead to a reportable event under all the state laws and federal landscape as well.
Thanks for that.
Great. And then just to cover really high level, the HIPAA basics. So who's subject to HIPAA? It's health plans, which include insurance companies and employer health plans. It includes healthcare clearinghouses, which are entities that transmit electronic health information, and then providers, if they are electronically billing for healthcare services. And then it's the business associates or the vendors that support those covered entities that's subject to HIPAA. So it is a narrow slice. It's not all medical information. And Reed will speak in a little bit about the non-HIPAA regulated health data under the purview of the FTC. And then the basics of HIPAA are the privacy rule, which very much governs the uses and disclosures of PHI, which is the medical information subject to HIPAA. And the general rule is that you can only use PHI for treatment, payment, or healthcare operations unless you've got authorization from the patient or the plan participants. There are other exceptions, but that's the basic rule. And then the security rule, which stands for the proposition that covered entities and their business associates must protect against reasonably anticipated threats and vulnerabilities that compromise electronic PHI. So privacy rule covers PHI in all format, oral, electronic, non-electronic, whereas the security rule is very much focused on electronic PHI. So that compromises PHI in electronic format in a way that's not permitted by the privacy rule. And then there's breach notification. So if there is an incident that results in unauthorized uses and disclosures of PHI, and it's determined that it compromises the data, then there are notification obligations to individuals, the government, OCR, and to the media within 60 days from when the breach has been discovered, if it impacts more than 500 individuals. Again, you always have to tell the individuals within 60 days, but if you have a smaller breach, you have a little bit more time. You can do an annual notification to OCR. And I should note that 60 days is really an outermost deadline. The statutory or the regulatory requirement is you need to notify without unreasonable delay and no later than 60 days.
Terrific. Thank you. I am mindful that in my experience as well, knowing who holds the data, what the data is, obviously is foundational. And I think we're going to see a lot of overlap, some challenging to solve due to potentially even conflicts in treatment. So
that's an excellent point. It's not always as easy as you think to know whether or not you're dealing with PHI.
Right.
And what regime.
Right.
And then what are the penalties that we're looking at? So the penalties are based on the level of culpability, with it going up when you get to willful neglect that's not corrected within 30 days. I should say these penalty amounts have been relatively static in the per violation field, although they have modestly increased for inflation. What is interesting is the maximum penalty per calendar year for identical violations has actually decreased. The Trump administration reviewed the statutory regime and has a different interpretation of how those caps work. So it used to be 1.5 million for each tier. It's now only 1.5 at the highest tier, being the willful neglect and not corrected. But there really is very little comfort to be taken by those caps. OCR has tremendous flexibility at the moment of how they calculate their civil monetary penalties. It can be per day, it can be per affected individual, per record. They also can take into account the financial wherewithal of the entity and whether or not the entity is a repeat offender. So that is helpful background to see what the penalties are, but you'll see, and we're about to talk about the latest enforcements, they do range in terms of dollars. And we just had in 2021, one settlement at 5.1 million. And I should talk a little bit about what that means. So in this case, the covered entity decided to enter into a corrective action plan, a CAP with OCR, and the benefit of entering into a corrective action plan with OCR is, generally speaking, that lowers the monetary penalty that needs to be paid. That's what this plan did. Their breach was due to a malware attack from December 2013 to May 2015. 9.3 million individuals had data exposed, including social security numbers. And OCR noted that, among other things, the plan had failed to complete an enterprise-wide HIPAA security risk assessment. So to put that all in context, that is a relatively large settlement with OCR in terms of dollars. 9.3 is the high level of individuals impacted. The failure to complete this HIPAA security risk assessment, looking at where your data is and the vulnerabilities to it, and failing to remediate to a reasonable level, is really foundational to HIPAA security. And so you do tend to see OCR calling out failures to comply with the HIPAA security risk assessment because it is so foundational. But in contrast, the only, or one of the other settlements that we have seen with OCR this year was the 18th enforcement action resulting from its right of access initiative. So as I said at the beginning, there is this real push to make sure individuals have access to their medical records, and failing to provide access under HIPAA is triggering regulatory review, enforcement actions by OCR. It's not breach related, but very much a focus of OCR in the last couple of years and continuing into the new administration. Now, the dollar settlements for failing to comply are relatively modest in comparison to the 5.1 million, but they are coming after all types of entities. So even small agencies that are helping the homeless have been the target of these enforcement actions.
So, Tor, it seems like in the first instance, we've got some that seem like they hadn't really gotten underway in the general HIPAA compliance, and they obviously took a strong position there. But it sounds like also the general activity on the enforcement side continues to grow as well. Is that accurate?
I think that's right. And, we also saw another one this week, which didn't make it into the slides because I think it literally happened yesterday, which was interesting because it grew out of a breach. In fact, the Veterans Affairs had a security breach involving their telehealth program, but it was managed by a business associate. And so OCR did a compliance review of that business associate and learned that that business associate had been acquired by another entity, and it's that entity that did the acquisition that entered into the settlement agreement. So it's just of note that typically I haven't seen them come out of corporate transactions, but we did this week. And that one is a 3-year corrective action plan and a need to have an independent monitor look over the shoulder of the entity that settled with OCR. And we haven't actually seen that in a while, that independent monitor and a corrective action plan lasting for 3 years. The trend has been to just 1 year and no independent monitor. But the fine was $25,000. So we're under, a new regime at the moment. We have an acting OCR director. We don't have a permanent placement. So I'll be curious to see who gets tapped to be the OCR director and what that might mean for enforcement actions going forward. But the acting OCR director, it's just interesting, has been at OCR since 2000 and has served this role as acting OCR director in between changes in administration over the last few changes, which is interesting to see what will happen.
Yeah, I think it's also, from a corporate standpoint, I think it's definitely the word to the wise that you can buy trouble here if you've got a situation with a target that hasn't really been minding what it needs to, whether that gets covered in acquisition documents or not. There's certainly the risk of damage to the organization, impairment of value also. So
agreed. And I think Reed and Eric can attest to the fact that we are spending more time with our corporate colleagues and looking at due diligence and in acquisitions and reps and warranties and looking at privacy and security.
Right. The fact that everyone does it this way isn't necessarily going to be the answer anymore. It's making sure that we've checked and complied. So I think next up, then we move into where we're going from here. And part of it, as you noted, we've got an interim director with the new administration, but there's some other activities on the horizon as well, it sounds like.
Agreed. So there's definitely been some interesting litigation, recent litigation. So as I said, the typical route when you are investigated by OCR is to enter into a resolution agreement and then have a slightly lesser monetary fine. That is not the route that the University of Texas MD Anderson Cancer Center took. They decided, we're just going to take the civil monetary penalty. We're not going to negotiate with OCR and enter into a corrective action plan. That can be very expensive because you have that independent monitor, you have to do the HIPAA security risk assessment and report in on your findings, and you are constantly before OCR with a level of scrutiny that you're typically not. So for many reasons, and I don't know all of them, this entity decided, okay, we'll take the $4 million penalty, and then we're going to litigate it, which is exactly what they did. And they actually won in the Fifth Circuit Court of Appeals. And one of the things that the court found was that OCR wasn't treating like cases similarly and were arbitrary and capricious in the way that they were assigning their penalties. So it'll be interesting to see if more entities challenge, don't enter into resolution agreements and then challenge the civil monetary penalties that are levied. And then really fascinating to me is at the end, or actually the beginning of January, Congress passed a law that doesn't have any fancy name, but it amends high tech. And what it says is that OCR has to consider when an entity is under investigation, whether or not it has recognized security practices that have been in place for at least 12 months. And if they do, that should mitigate against fines and any remedies resulting from enforcement actions. So I haven't seen a lot of buzz about this yet. Don't know exactly where it's going. I don't know, Eric, whether you have thoughts about what those recognized security practices might look like.
Right. Doesn't it point to the NIST cybersecurity framework?
It does indeed. It does indeed. And
it
then
does,
it has
yeah.
and then it has an opening for programs under other regimes.
Right. And for those of you who don't know, the NIST cybersecurity framework was a framework put out by NIST during the Obama administration, which has become adopted and by the marketplace, and it was sort of a result of public-private collaboration. And so it's increasingly being pointed to sort of as a recognized reasonable practice. And so that's why the level of adoption has been so significant.
I think off of that, actually, just to hold on one last point on the slide, that I imagine generally many of the clients and folks who've been seeking help have probably been wanting direction as to what exactly is the standard. And it sounds like there's movement in that direction, but we're not there yet.
But very much not prescriptive, right? So NIST has some latitude in it, but at least telling you what regimes to be looking at.
Right. Excellent. All right, with that, I think we'll end up moving ahead. Then I'm going to turn to you, Reed, and we'll dive into the Federal Trade Commission and then hear a little more about their perspective on this topic. So maybe you want to start with giving us a little background on where they're playing, what their authority is.
Right. So can you hear me?
Absolutely.
Okay, good. So let me begin by saying that I practiced there and I practiced before the Federal Trade Commission for a long time. And what was curious to me was under the previous administration, there was a lot of rollback of rules, a lot of lower enforcement of rules. And the FTC was the most aggressive it has ever been since I started there in 1996. It is becoming more and more and more aggressive all the time. And this was under 3 Republican commissioners and 2 Democrats. And now we will have 3 Democratic commissioners, a Democratic chairman, and 2 Republicans. And so, traditionally you can expect that the FTC will become more aggressive, and the dissents filed by the Democrats when they were in the minority give a real roadmap to just how aggressive they want to be when they hold the levers, and which they do now. So what is the FTC? The Federal Trade Commission is an independent agency created by Congress in 1914, and to be kind of an expert on business. It has morphed into over 110 or 15 years to be an enforcement agency, an agency that provides consumer guidance, an agency that provides business guidance, an agency that is a real thought leader on privacy and data security, and it also does competition, advertising, and other things. The breadth of the FTC's jurisdiction is, I can say it in the negative. It's everything unless you are covered by the Packard and Stockyards Act, or a nonprofit, or a common carrier. Although the FTC thinks that if you're a common carrier, the only thing it can't go after you for is common carrying. But advertising, privacy, data security, they think they have the authority to regulate and enforce their law. Their main enabling statute is the Federal Trade Commission Act, and it's about 50 pages long, and only a few words matter. Deceptive and unfair practices are hereby declared unlawful. Deception is a representation or material omission about a fact that would reasonably mislead a consumer under the circumstances. Unfairness is an act or practice that is likely to cause substantial injury, is unavoidable by the consumer, and doesn't do any. There's no outweighing of benefits to competition or consumers by the act. So a lot of the data security cases have been brought under unfairness because the company hasn't said anything about data security, but they had a breach, and the FTC's theory was, well, you caused substantial consumer injury. No consumer could have avoided it, and there was no benefit otherwise to what you did. And so unfairness has been their menu of choice for breach actions. They also bring actions against companies, not just in the event of breaches, but also for claims they make about their data security, and then what their reasonable security measures are to protect health data. It's interesting also to note that they've brought cases where there was no breach, but somebody blogged that such and such had a vulnerability, and the FTC brought a case and got an order for it. The FTC, when I say the FTC, I'm talking about the 5 commissioners and the staff in the Division of Privacy and Identity Protection who handle this. They have long considered health data to be sensitive data. That means a lot of things in a lot of contexts, but in this context, it means a breach involving health data that's not regulated by HIPAA, but regulated by, that doesn't fall within those parameters of HIPAA, but is regulated by the FTC, rises to the top for the FTC in terms of investigations and enforcement actions. We can move to the next slide.
Well, a couple follow questions, Reed, is it sounds like the thrust and a lot of the FTC overview is on the security side, but it's also deceptive practices. They kind of play in both. Is that right?
Oh, yeah, absolutely. Absolutely. Privacy and data security at the FTC are involve deception and unfairness. Unfairness could be, the undisclosed tracking of consumers across on your TV now, your connected TV, and so yes, the FTC does use this deception authority, and they are using it more and more aggressively and seeking stronger and stronger remedies. So
one of the other things too is the distinction, or is there a distinction between PHR and PHI as it relates to the general activity?
So that's a good question. There are all these acronyms, kind of like the Army. I think they have an acronym for a paperclip at the Army, but it's essentially the same thing, except that PHR is not regulated by HIPAA. So a personal health record is defined as an electronic record of identifiable health information on an individual that can be drawn from multiple sources and that is managed, shared, and controlled by or primarily for the individual. So it's an electronic health record. It's just not a HIPAA regulated electronic health record.
Good. Yeah, it's an interesting distinction they have. Again, going back to occasionally there's coordination among the agencies, but not always in the air. We've got some overlap. So
we do, and I think the FTC and the OCR talk. I mean, the FTC's jurisdiction overlaps with the state AGs, with OCR, with the FCC, with the SEC, with the Department of Justice. So they play in a lot of sandboxes and have a lot of partners. In fact, as I'm sure Eric will talk about, the FTC often participates in multi-state enforcement actions where the FTC is one of the plaintiffs, and a number of states are plaintiffs. I did one of those when I was there. I brought a case on behalf of the FTC, and several states also signed on to the complaint, so that they cooperate and work together. So the health breach notification rule is the real issue here for breach. It is a rule that has been underused by the FTC, and it is under review by the FTC. What do we know about the health breach notification rule? First of all, I'll say what it does is it requires companies that handle these personal health records to provide notification of the breach of this personal health record information if it is unsecured as defined by HHS. And there is also, as Laura mentioned, for HIPAA, a numerical threshold. So the PHR-related entities must notify consumers in the event of the acquisition of unsecured PHR information. But for breaches involving more than 500 individuals, the rule requires notice to the FTC and in some cases the media. So the FTC can enforce violations of the rule as under Section 19 of the FTC Act on a per violation basis. The current amount of a rule violation civil penalty is $43,792 per violation, up to there are a number of factors to consider when they bring a case, but you have a breach involves a million records. The FTC is in a pretty good negotiating position with you, and maybe a little bit too good of a negotiating position, as I've told them. The health breach notification rule is really the most important thing here. And even though the rule has not been enforced, it is going to be enforced under this FTC. In a recent case involving the disclosure of consumer health data, the commission is called Flow Health. You can see on the next slide, Jen. This case, Flow Health. There was a disclosure of consumer health data, and the FTC did not bring a health breach notification rule claim, and the two Democratic commissioners dissented, saying that they didn't understand why the FTC didn't bring a health breach notification rule claim and get civil penalties for that. The rule is undergoing comment and review, and there may be changes to it, but I expect it to be enforced, and it's not typical, but in this case I expect it that it will be enforced. In the meantime, the current chairwoman, and I don't mean this in any way other than descriptive, is an activist acting chairwoman, and she may get the permanent chairmanship. If not, she's a very vocal voice at the FTC, and she is a very aggressive regulator. So one last thing I'll leave you with is the remedies in FTC breach cases, whether it's failing to comply with the health breach notification rule, or an unfairness or deception case involving a data breach. The FTC is looking for new types of remedies. They're looking for disgorgement of ill-gotten gains, and they're looking for any way they can to get money from companies. The Supreme Court just threw through that in the mix, and now Congress will have to deal with the FTC's ability, outside of getting civil penalties, to get equitable monetary relief. But it's a huge priority for the acting chairwoman. And also, she has made it very plain that in cases of this nature, where there's been an unauthorized disclosure, there should be notice by the company to consumers. Your data was leaked, and this is the fix we made. But a direct notice by the company to the consumer, to the consumers involved, of what happened and how, and what they can do to protect themselves. And that's new at the FTC, and I expect we'll see more of it. And with that, I'll turn it over to any questions, and then to Eric.
Yeah, I think in rounding up on that, it is notable, I think, for the FTC that between its own change of administration and, as you described, more activist stances seems likely, plus the Supreme Court case, which I noted kind of shifts things on remedies. It seems like a fluid time, but I wouldn't suspect anything is going to become more passive. As you noted, it's likely to become more active. So
no, we're in for a wild ride at the FTC under this administration. I'll just note the president appointed or nominated Lena Khan, who had graduated from law school in 2017, but wrote a seminal article on the the antitrust laws failing to keep pace with current tech company behavior, and that's a signal by the Biden administration to the tech community that they are not as dear as they once were.
Right, right. So stay tuned. We'll see what evolves there. So
Yeah.
I think with that, we'll shift over into the state area. I do want to mention before we get into that, three things. One is if you've got questions, again, please include them. We'll look to get to them. And if we don't, we'll certainly do written follow-ups. Also, for everyone's benefit, I hadn't mentioned, but we are going to be posting the PowerPoint on our site. So if anyone wants to get a copy of it, we can make it available. And lastly, this is available for CLE credit. So the code is Healthcare 2021. So for anyone seeking CLE credit, just include Healthcare 2021 as the code, and you'll earn your CLE for today. So with that, I think let's move into the states and hear from Eric.
Thanks, Jim. And dropping that CLE code right before I started is unfair. Hi, everybody. So as Jim said, I'll be discussing this issue at the state level because a significant part of my practice is helping companies navigate data security and data breach notification investigations. As I mentioned, I served 2 stints in the Illinois AG's office, so I've seen this issue from both the public sector side and the private sector side. And if you've dealt with investigations and enforcement actions at the state level, you know that it can be tricky given the patchwork of state laws and agencies that play a role with data security, data breaches, and data breach notification. So first, as the slide shows, I'd like to start with state attorneys general, who play an incredibly important role on this issue across the country. As Reed mentioned, just like the FTC, the states also have very broad authority over consumer protection issues. And although they vary, states have what's sort of described as mini FTC acts. These statutes are known as UDAP statutes. I guess, Reed, we have our acronyms at the state level too. And they stand for, UDAP stands for the general prohibition, which we discussed, but it's the general prohibition against unfair and deceptive acts and practices. And like the FTC, the states got involved in data security and privacy at the outset, the state AGs, I should say, with this very broad consumer protection authority. However, it's worth noting that over the years, the states have also passed their own laws on both data security and data breach notification. And these state laws, this development, is what I keep referring to as the patchwork. These requirements, and you can sort of see some of them here on the screen, but these requirements vary from state to state. In general terms, they require companies to notify individuals when their personal information has been part of a data breach. California was the first state to pass a law on this, and every other state has now followed suit. It took a while, but now all 50 states do have their own version of a data breach notification law. Originally, it's important to note that these statutes were limited to the kinds of information that could lead to identity theft. And it really came out of this identity theft issue because a lot of states have their own sort of constituent service phone numbers, and identity theft for years was the sort of #1 or #2 complaint, and the offices were dealing with it on a regular basis. And so in response, the states and the state AGs pushed to pass laws to require notification when information that could lead to identity theft would be part of a breach. So that's why you see social security numbers, driver's license numbers, and the like being part of what's defined as personal information. However, and this is where health information comes into play, this definition has been expanded, and it continues to be expanded by the states on a yearly basis. So I do want to note that that there are 22 state data breach statutes that include health or medical data within the definition of personal information. And Tor has already discussed HIPAA, and I want to note that and Tor may want to jump in on this too, there are HIPAA exemptions at the state level. And so a number of these statutes include exemptions for companies that are both subject to and complying with HIPAA, so that if you're complying with HIPAA's notification requirements, then you would be complying with some of the provisions of the state notification law. But at the same time, I think it's also very important to note that what is being exempted differs on a state-by-state basis, and it's very important to look at the specific provisions of the state law to understand what you still have to comply with that state law, even if you're complying with HIPAA. Tor, did you want to add anything to that?
Just to underscore the level of complexity of those exemptions, sometimes it is just the mere information that needs to be included in the state law notice is preemptive if you are complying with the HIPAA notice requirements. Sometimes it is the entire state law you don't need to comply with if you're complying with HIPAA, and then sometimes it's state law will have very specific notice periods, as you mentioned, Eric, for notifying individuals and sometimes the Attorney General, and there'll be a different time period if you are subject to HIPAA. So it is, if you're talking about a large scale breach, it really is that patchwork of OCR, if it's HIPAA data, FTC, if it's not HIPAA data, and then all of the various state laws.
I guess with that said, is there any, I guess I'll say, hope that there might be a federal intervention to give us a single standard or some statutory basis?
Yeah, Jim, that's a great question. And Reed and I sort of follow this on a daily basis, but this has been an ongoing discussion for over 15 years on data breach notification specifically. And then even more importantly, recently, because states are, and this is beyond the scope of what we're talking about today, but states are now passing comprehensive privacy regimes as well. And there's certainly an effort at this federal level to do something. When that will happen is really anybody's guess. But if you've been betting it against it not happening, quote unquote, this year, you've been making the right bet for a very long time. So, and you know, Jim, we discussed this a little bit in prep, that just that, you know, this process of a patchwork leading to a federal law it's happened before. You can go look at all the trucking regulations that were out there, state by state. Back in the sort of once we started to figure out that transportation was something that we needed to regulate, the states moved first. Eventually, the federal government got involved, but it took a very long time, and we're still at the very beginning of this process.
Right, I think that's important to note. It's we've been here before, but it takes a while.
Absolutely, and we're living it. I do want to mention that the states also have, they've also formally passed their own laws requiring quote unquote reasonable data security practices, which supplements and strengthens the power they already have under their UDAP laws. And I'll discuss that further when I discuss some of the recent settlements that the AGs have achieved. So when discussing data breach notification, though, at the state level, it's really important, and you'll keep hearing me and Tora and others say this, which is the patchwork is different state by state. It's very important to understand what your requirements are on a state by state basis. And I'm just going to take a moment to highlight some of the distinctions that are out there that are very relevant. The first one are there are actually different definitions of what a breach even constitutes under state law when it comes to triggering a notification requirement. And what I mean by that is, just by way of example, if you've uncovered a data breach, it's confirmed that the data was exfiltrated by some bad actor, this data was not encrypted, then you are going to have to notify across the board because that's what's known as acquisition. But if you have a breach that maybe someone got into the system in some fashion, but you're able to confirm that no data was exfiltrated and they only had access, some states only require notification when there is acquisition. Some states require notification when there is either access or acquisition. So the nature of the breach itself is very relevant for the determination on whether or not you have to provide notification to individuals.
Is there any general trend going on with states? I mean, or is it more popular to do access versus acquisition, or where's that going?
Yeah, I mean, look, historically, it was more tied to acquisition because that goes back, if we talk about the underlying reason for these statutes in the first place, which is identity theft. Well, if someone's exfiltrated the data and it's unencrypted, then you would want to notify somebody so they can take steps to prevent identity theft. However, over time, there has been a movement to expand them. And so what you're seeing is over time, states amending their laws to broaden it to access as well. Which
And
is
how's
bad news.
As an aside, I mean, how do you even make that assessment?
Right. So, and this goes into sort of what the role that outside counsel play and forensic experts. But what you would do is you would, when a company discovers they have some kind of data breach that they're dealing with, but they're trying to get their arms around it, you want to make sure you get counsel involved, both in-house and outside counsel that specialize in this. And then under the rubric of the attorney-client privilege, you're going to bring in a forensic expert who's going to take a close look at the system to understand and look at log files to understand what exactly happened. And once they have done that, and they've given their view on whether there was acquisition or whether there was access or whether or not you can't determine it, based upon that information, your outside counsel working with in-house counsel are going to make recommendations and provide advice on the risks associated with notification based upon whatever the evidence shows.
Great, thanks.
And just a couple, I know we're getting sort of toward the end of our time here, but I did want to flag that there are a couple other important distinctions among the states. One is timing for notification to individuals. Some states require notification just in a quote unquote reasonable amount of time. Some states have very specific requirements like within 30 days. But even then, it's important to determine when the actual event occurred. It's important to determine, because the states will say you have to notify within 30 days of determining you had a data breach. Well, it's one thing to understand that you've just had some impact on your system. It's another thing to understand, not only we've had an impact on our system, but now we know that personal information has been affected. And so it's just important to figure out what that date is, because at some point, which we'll get into, you may have the AGs asking you questions about it. And the last distinction I want to highlight is just the notification to state AGs or state agencies generally. There are some states require notification to the Attorney General and to other agencies. Some require notification if you've only had literally one person in the state affected. Some states have higher thresholds, like 250 or 500 individuals have to be affected first. And it's also important to note that when you notify the state, some states will it will just disappear. They'll keep it internally and they won't share it. Some states will publish your notification on their website. Of course, that can't impact whether you notify them or not, but it's important to note what you're sort of getting yourself into by notification. And Jim, you can go to the next slide now. This just highlights some of the recent Attorney General settlements that have been out there that are related to the health space specifically, and I'll talk a little bit about them, but I do want to provide some context for what happens and how the AGs end up with these settlements. So once a breach occurs and notification is provided to individuals and to state AGs, more often than not, you will start to receive requests for information about the breach and about the notification process from the attorneys general. Not surprisingly, the more significant or the larger the breach, the more likely it is that you're going to get interest. And these requests for information can come in various ways. They could come in informally at first from the assistant attorney general who is in charge of the issue within their state. It could happen on a state-by-state basis where it's not the states working together. But then, and I've been involved in these as well, not currently, but in the past, where a breach can be so significant that it immediately leads to a multi-state outreach, and the states start working together very quickly and send a CID, a subpoena, to request information formally within a matter of days or a week of actually notifying them. And just a little more information on the multi-state process that Reed referenced a little bit as well. The state AGs frequently combine efforts where it's called a multi-state investigation. They will have an executive committee of a few states, a handful that are sort of directing the investigation. And then among the executive committee, you'll have a couple states that will be the leaders of the investigation, negotiating with outside counsel, and sort of be the interface for the states. And typically, if they decide that, if the company decides to settle and wants to resolve the matter, the state AGs will agree across the board so you can settle all the cases at one time, but that's not always the case. I know we're running slow on time, so I will finish up there. But I just want to say that these settlements just show that the state AGs have been paying more and more attention to HIPAA data breaches in recent years, especially with the Anthem breach. And then finally, just to mention a few other additional state agencies that are very relevant. I should say at the outset that this is not a full list. There are certainly other agencies. There are some other federal agencies we haven't mentioned related. So the SEC is relevant as well. But I did want to flag a couple that are very important. One being the New York Department of Financial Services. The NYDFS, which has regulation over insurance companies among other entities, passed a regulation in 2017 that places cybersecurity requirements on covered entities. And these requirements are much more prescriptive than the broader reasonable security requirements that I referenced and that we've been talking about. There are a number of things that companies have to comply with. In addition, there is a notification requirement for 72 hours once a determination of a reportable cybersecurity event has occurred. And what distinguishes that from the notification requirements that I already referenced from all the other states that are related to the AGs is that this notification only requires a reasonable likelihood of material or harming any part of the normal operation of the covered entity, which means it does not have to be related to, it could be related to a exfiltration or access to consumer data, but it doesn't have to be. And so it's certainly broader than the notification requirements I've just spoken of. And I do want to mention that the NYDFS is now finally moving forward on investigations and settlements. It's just announced 2 settlements in the last couple months. One is with the National Securities Corporation, where they had to pay a $3 million penalty. And the NYDFS mentioned that they'd failed to implement multi-factor authentication as part of the reason for the settlement. And then Residential Mortgage Services failed to properly, in the view of NYDFS, failed to properly report a breach to the agency, and they had to pay a $1.5 million penalty. And I'll end with, I wanted to at least flag this, is that the departments of insurance at the state level have a number of them, I think around a dozen or so, have adopted the NAIC Insurance Data Security Model Law, which it's a model notification requirement. A number of states have adopted it. Some have gone on their own to adopt different ones as well. But just to say that departments of insurance are also relevant. Tor, did you want to add anything to that last point?
I struggle to get myself unmuted. No, I think that's good. I think you've covered it in light of the time. But yeah. It just does add to the flavor of when you do have something that's reportable, thinking through all the various agencies that need to be reported to.
Yeah, I think, I mean, it shouts out the patchwork of coverage here, federal, state, different agencies, federal, different activity at the state level, and obviously much more awareness and notoriety going on. I think there's going to be pressure on public officials to be all the more active, not less. So really great discussion. So I thank Tora, Reed, Eric, I appreciate you for your time and presentation here. Ladies and gentlemen, thank you for joining us. I hope you got some good information here. As we said, if we didn't get to all of the questions, we're happy to follow up in writing. We also, or I want to let everyone know, this is part of a series. We've got these additional presentations coming up. I think they're also listed on our site. So we'll look forward to welcoming the group back. So I appreciate everyone spending their time with us today, and hope you have great afternoons, and hope to see you again soon. Thank you.